lots of conversations going on to make sure that as we bring this bill back up, that we give it its due diligence and work and see where it goes. Of course, the committee did pass this out, and then it was not. It was above the line, got referred back to, was blessed and referred back to our committee. So this is where we are. And I tend to do things a little bit unconventional, and so this is going to be another one of those days. Because the importance of this bill, this will be more than simply just some final action and going through this, but we do have some expertise in the audience. We want to make sure the committee fully understands. And so while others may not let this be a participatory venture, we ask if you're here in the audience, if you're asked to come and bring some clarification, if you would do that. So I just want that to keep in mind. So if you are called upon, the chair and the vice and the ranking have agreed. So with that, we will open up. This will not be a full hearing by any means, but we do want to do some more discussion on it and see if it passes back out and then moves forward. So this is on House Bill 2531. I think everybody knows what it's about. And so with that, what's that? Well, if the people at home don't know, it's a beautiful day to get in their car and they should have left earlier to be here. So if those that are listening and watching do not know, House Bill 2531 is dealing with right-of-way on country roads and township roads to install, maintain, and operate one of our pipelines for agriculture activities. This has been one that has had a lot of discussion, but I believe it deserves some more. So with that, committee, I will call on Representative Carlin.
Do you need a motion to work the bill, or you want me to tell you what I'd like to do with the bill? I know.
I think I would just open up for discussion. That's why I'll call on you, Representative Carlin.
Okay, thank you, Mr. Chair. Well, after we passed this bill the other day, I've been contacted by a lot of people that had a lot of interest in things that I care about a great deal, such as property rights. And while I was a leader in getting the actions done that we used to amend the bill last time, I thought those were the things I understood, and the things we needed to do was communicate with landowners and be sure everybody understood what was about to happen to their property. And I thought that was okay if the county said it was okay. In the meantime, I've been given copies of things like, and I don't even have them here. I've got all these papers and probably don't have what I need. But the Fifth Amendment to the United States Constitution, the 14th Amendment to the Kansas Constitution, which deal with right-of-way and private property and who's in control of the land. So it's given me great pause. In '07, I wrote a bill in cooperation with Kansas Farm Bureau regarding the takings of land from an individual for eminent domain, with eminent domain for economic development purposes. And the bill was about, we had a study committee about it, and it was a summer-long thing. John Brattle was the chair, and there was a co-chair. I don't remember who it was. But what we did was we studied the issue of, the Farm Bureau's concern was, you know, you've got a farm out here on the edge of town and the city wants to pull it into and put a mall there and they can eminent domain your property. And that was the case. So we wrote a bill to clarify that if someone is getting an economic personal development benefit from taking and using your land, that they had certain things they had to do. So I would like to consider that as part of this bill. If we do something to try to make this elephant better, I think one of the things we need to do is to include some phrases about this being a taking for someone's personal gain, that it should go through the eminent domain law applying to that purpose. And in that is part of the amendment that I've worked with Kyle on, and there are lots of other parts, but I think this is the one that concerned me the most because I had so much invested in that process years ago. If you're getting a profit from taking my land, I need to be compensated. And in this case that we've seen, the landowner was not only not compensated, but he was not even consulted. So we fixed the consulting part the other day, and we did a good job with that, I thought, but we didn't get into the property rights issue. And I'm going to ask Kyle at some point to explain what I'm talking about with the amendments to the Constitution and what they say about right-of-way and county ownership and right-of-way easements. And can you, I don't know whether, maybe that's where we are right now.
I think so.
Okay. Kyle, do you have that? Because I don't think. Oh. Well,
Yeah, her
the
amendment.
amendment can come out now. That would be fine.
That's fine. So we'll have the amendment and then, then we can discuss.
Thank you, Mr. Chair.
Yes.
Just I don't know if we're doing discussion or are we actually debating the amendment? Because if that's the case, I don't think we have a motion on the bill. Are we just discussing?
We're just discussing right now. It's kind of an open discussion rather than, yes. What's that?
Mr. Chair,
Yes. Once it's distributed, I will ask for a motion. Okay. Everybody has one? Everybody has a copy? Representative Carlin, a motion will be in order.
Mr. Chair, I move that we amend House Bill 2531 with the amendment that's been passed out. We may need to vote on individual pieces of that, Mr. Chair, but that would be my motion at this time.
Oh, second? Seconded. All those in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carried.
We really can't vote on it.
Oh, I'm sorry.
All right, I guess we go.
We really need to read it.
All right. So I'm sorry. You're right. Long day already. Representative Carlin, you explain your amendment?
Okay.
If you'd like to explain your
I would
amendment
like
section
Kyle
by
to
section.
I would like Kyle to
Okay.
explain the amendment section by section, and then we can ask him questions or something. You know, I'm not quite ready to do all of it. It's lengthy. Thank you, Mr. Chair. Kyle, if you would go ahead.
Thank you, Mr. Chairman. So you'll see starting on page 1, line 7, and throughout the bill, anytime the Board of County Commissioners is referenced, there would be an additional reference added to or Board of Township Trustees. And in the first section, that is sort of the general statement about being able to have these pipelines approved, language would be put in on line 12 saying that the approval would need to be in conformity with the United States Constitution. That's the old language already says laws and regulations of the state of Kansas and the county where the pipeline is located. And then subsection B, which was the grandfather clause language, would be completely stricken. And there would be some changes to the approval process. It would say that a failure to approve the application by resolution within 90 days would be deemed the denial of the application, which is a bit of a reversal of what the current bill says, because the bill currently says that after enough amount of time has passed, then the application is deemed approved automatically, but this would say it would be denied automatically if the board or the board of township trustees haven't acted. Furthermore, page 2, lines 6 and 9 would be stricken. That talks about the decision-making process of the county commissioners. That language had said that the decision would be limited to whether the pipeline interferes with public travel upon the road, the management of conflicting uses of the road right-of-way, or the ability of the county or township to maintain the road or road right-of-way. So that would be stricken from and not part of their consideration. Instead, the only requirement is that the decision to approve or deny would be reasonable and not arbitrary, capricious, or discriminatory. And then in line 18, another strike, the requirements of the owner, potential requirements, they would have to repair all damage caused by the activities of the owner, not just damage to a road or road right-of-way. And then we would be adding some additional language there in subsection F. You can see the new subparagraphs C through F that would be added. So that would read, if you're starting with the F1 language, a county commission or board of township trustees may require the owner of a pipeline approved under this section 2, subparagraph C, absorb any costs related to signage, notification, or other safety precautions associated with occupying, installing, repairing, or maintaining the pipeline in a road or road right-of-way. D, pay 125% of market value as just compensation to affected landowners for taking of private property. E, remove the pipeline at no cost to the county or township if the pipeline is deemed to be a danger to the public welfare of the county. And F, provide bond or liability insurance to cover costs of pipeline removal should pipeline ownership be abandoned or if the owner should become deceased. And then you'll see in the remainder of page 2 that upon a request of the county commission or board of township trustees, the owner could be required to promptly relocate, adjust, and then the balloon adds the word remove or removal anytime those preceding words occur. And then lastly, on page 3, line 8, we would be inserting a new subsection K. It would say, the county or township shall use eminent domain for agricultural pipelines if affected landowners deny permission. Thank you, Mr. Chairman.
Representative Carlin?
That was a lot to absorb for most of us because this has been a pretty complicated situation. But I do think that what this offers us are things that could keep us moving ahead with the development of pipelines as well as protecting the rights of the landowners. We just hadn't done enough to protect them. In the Constitution, and I'm going to paraphrase because I don't know why my copy isn't here, but it isn't here. The county in right-of-way issues, thank you, Kyle. Which one, is this the one I want?
So this is the state constitution, and then this is...
I haven't got through that one. The county gets an easement to build a road. I'm going to paraphrase because I don't know the language. And the landowner gives that easement through eminent domain because it's a public use. And counties that build the road usually compensate the owner, but the owner can say, it's okay, build the road, I need it to travel, it's good for me, it's good for everybody. But they can be compensated by the road project. So the county then owns an easement. Oh, wait. It's too complicated, and I have ADD. I can't talk to you and me. The county owns the easement to build the road and maintain it. And as such, the bill presented to us, ways that the county had to protect the public. When the pipeline goes in, then the county has to protect the public from any damage to the road, and so it's a safe road. And so when we got to looking at it, the only real responsibility or authority of the county is to create the road and maintain it. And they work with a landowner to build it, and they give eminent domain process. However they settle it, it's through a process that's spelled out in the eminent domain law. So the right-of-way then for a pipeline, now the utilities is a different matter, because utilities would be like the road, and I don't know their law. I haven't even looked at it, but they're like a road. They can get a right-of-way for public good. But for personal gain, if I'm going to build a pipeline so that my farm prospers, that's economic development for me. And so the process then would include the law we wrote on eminent domain for economic development. And what this whole thing asks is that if somebody wants to put a pipeline on my right-of-way, I still own it. They have to come through me, and they have to go through an eminent domain process or settle with me. It provides for them to make a settlement without going through that process. But if it has to be condemned so that you can get the pipeline, then there's a process, and it's spelled out in that law that we wrote in '07. And I'd like to stop there and see if anybody has any questions for me, because the other pieces are totally off that. Or for Kyle.
Are there questions? Questions on so far? Representative Fairchild.
Thank you, Mr. Chairman. I guess I'm just kind of wondering, how utilities can be seen as being a public use when we're still talking about private companies, but yet, for agricultural use, it's seen as strictly being private use, but yet, the pipelines for agricultural use, that still affects a lot of people, and it, still affects a lot of different things. From my perspective, it still seems to me like it's private use in either case, either for agriculture or for utilities. And I just think that with this bill, we're basically just giving agriculture the same rights that utilities and everybody else has. And so, that's just my perspective.
Representative Carlin.
Thank you. Thank you, Mr. Chair. And in the first part of the bill, Section 1, it says, any person engaged in agricultural activity may construct, maintain, and operate pipelines in pursuit of an agricultural activity. Yes, agriculture is for the benefit of everyone. Whoa, where am I coming through? But it is not the same as a telephone line or an electric line that is for the good of the world at large. I mean, if you have a telephone, you can talk to people all over the world. That's a greater good than my farm, any person. And that's the way I see that. I'm sure there's better language.
Representative Probst, did you have?
Thank you, Mr. Chair. Yeah, I was going to echo that. There is, on that definition, I could in theory agree with the idea that individual operation benefits a lot of people, but we do have definitions in statute that I think we have to be aware of. And the public use of a right-of-way for things like utility lines and the sort, that affects a broader population. I guess I kind of just wanted to go through a couple of things here, thinking about our discussion last time and maybe some things in this that should be considered. we kind of limit our discussion before to county commissioners, and it does seem there is probably a need to bring in townships because there are some roads that are under township control. So I think that's probably necessary. And I'll defer to the people who have been county commissioners or on township boards, but just from my view, it looks like that's probably something we should make sure is in here. So I don't really have an issue with many of these things. And then when we get to where we strike line 18 and 21 on page 2, I was a little uncomfortable on first reading of that. But then I realized that because I felt like that was taking a lot of authority away from county commissioners. But then I realized that it says that they may require these things. So it feels like that still allows some flexibility within the county commission or the township board to take up those issues. Well, on line 16, if you look at that, the question was if I'd expand on that a little bit. If you look at line 16 on page 2, it says the county commission or board of township trustees may require the owner of a pipeline approved under this section 2. Then we strike 18 through 21 and we bring these other components in and we have this blowout box with C, D, E, and F. My reading of that, and I would ask the revisers to correct me if I'm wrong, is that allows some flexibility for county commissioners to address those specific issues. I don't know. I'm just curious for the purposes of discussion. Yeah.
Thank you, Mr. Chairman. Regarding that list that is that follows subsection F, you are correct. It says that the county commission or board of township trustees may require the owner to fulfill the items that are listed below. So it is discretionary.
And if I can continue on that thread, I think for me, something like this that creates maybe like a best practice or a benchmark, but still allows county commissioners. The one thing I don't want to happen is if we have an agreeable landowner who says, sure, go ahead and do it. I don't want to have a process created where we have to do every one of these things every single time, even if you have people being good neighbors and they can get along. So if there's no problem, I mean, it seems like if this is the sort of thing that gets triggered when there is an issue, but if there isn't an issue, people can get along and work it out. I like that flexibility. So I guess I'm just trying to create discussion around what we want to do. I don't want to see this bill back in this committee again. I'm sure you don't either.
Okay. Representative Murphy?
Yeah, and I was thinking, thank you, Chairman. I was thinking part of the reason this whole thing was brought to us was because we're trying to fix a situation with existing pipelines, and this takes that out. So we're not, isn't that the way that is? So now you're going to have a bunch of pipelines that are suddenly illegal. Is that the way I read it?
Kyle?
The amendment would remove the grandfather clause on page 1.
Representative Carlin?
Thank you. And Kyle, if I might ask Kyle, we all hear the word grandfathering and it has a meaning. It must have a definition somewhere. The thing is, if you carte blanche grandfather everything in the state in that we don't even know about, that's a pretty big move. I think if we leave it out, then they can still be judged on their merits in each case. Is that maybe, so I guess my question, Kyle, is grandfathering in this case would mean everything in the state that's already in existence.
The language on page 115 has some qualifying language. It starts by saying, except for pipelines installed in violation of an express prohibition of the Board of County Commissioners in effect at the time of such installation. And then it carries on with the main provision of that grandfather clause saying that all pipelines for use in an agricultural activity installed et cetera, prior to the effective date of this section are deemed to have been authorized by the Board of County Commissioners and are ratified as permitted uses of such rights of way. Otherwise, with the language removed, they would be subject to the requirements of this bill.
I might.
Senator Carlin?
So my concern is, what if there are pipelines that have already been tried and denied and maybe have, I mean, I just don't know who, I don't know if we have to make an exception for those who've been Attorney General opinions or court cases or decisions on, I mean, it just seemed too broad to me.
All right, Representative Minix?
Thank you, Mr. Chairman. I'm a strong proponent of the grandfather clause because there were quite a few pipelines put in the past, and the adjacent landowners did not have a problem with those. There was no protest. They have had no objection to those that I'm aware of on the ones I'm thinking of, the ones that were put in without, how is it put, in violation of an express is in the phrasing there. So putting the grandfather clause in would allow those pipelines in the past to be held in the same manner as what the ones in the future would be held if you do pass this amendment. They would have the same legal standing, in my opinion. So I think that grandfather clause is very necessary that we have in. If you have some that there's been an objection on, they aren't covered here.
That's what my concern is. I mean, I hear you, and if everybody's fine with it, and then, okay, so there's a pipeline going through my right-of-way, my ditch, and I'm fine with it, and everybody's fine with it, and then somebody new moves in, and they're not fine with it. So in that case, grandfathering makes sense. See what I'm saying? So a new neighbor coming in and raising objections to a smell or something, I mean, that's...
When there's a property transaction in the state of Kansas, I think you're assuming whatever came before when you buy that property, and that's throughout our state statutes. And I just see this as treating the pipelines that have been in the past in the same manner that we would like to treat the ones in the future, with full disclosure, total notification to all adjacent landowners. If they wanted to have money paid to them for something, I far prefer that to, let's say your last line on the amendment, county being able to go through eminent domain and taking of the land for a private purpose. I'm not quite ready to go that far.
Representative Seibert?
Thank you, Mr. Chairman. I guess I'm a little confused on, are you talking about the ditch in front of people's houses or right away? Because you do maybe own it, but you don't. But if you look at an abstract, it says you buy 160 acres, and it's surveyed out to the center of the road. But the deed says you only own less the right of way and easements of record. So what we're saying is the landowner does not have any say in what goes past that survey stake of the easement or right-of-way. As a township person, we could then have to ask permission. We basically were granted that possession, and it's on your deed and abstract. So I guess my question is, to the reviser, does not the abstract for a piece of property that you buy say less all easements and right-of-way to record?
Gosh, off the top of my head, I don't think I'd be able to answer that directly. But in general, anytime that there is a right-of-way of any parcel of road, that is going to be very clearly laid out in records held by the county. So you'd be able to find out what the exact parameters of that right-of-way are.
Well, as a landowner, I got that on every deed or property that I own. I cannot do anything on that right-of-way, even though I supposedly own it to the center of the road. I do not pay taxes to it because the deed says less 160 acres, total cropland or property is 155. So that gives the counties and the local government control of that easement. You do not have to pay that landowner if you stay on that right-of-way, because he does not own that right-of-way. That's in charge of the county. And that's on the deed and the abstract when you sell it. That says that's not the landowner's minus, you own that property minus the easements and right-of-way as of record.
All right. We'll go quickly to Representative Carlin, then we'll go to Representative Fairchild.
Thank you, Mr. Chair. I'm looking at the piece from the right-of-way from our what is this, KSA? Is this the Constitution?
Statute.
That is the.
Eminent domain?
That's a constitution.
This is the Constitution of the state of Kansas. No right-of-way.
Okay.
Talking to Cywert.
That's fine. Representative Cywert, I think she may have an answer.
According to our Constitution,
I'm
it
sorry,
says
what was the
no.
deal?
She's going to.
I'm answering you. I wanted to wait till you were ready.
Oh, I'm sorry, we were talking about the right-of-ways and the easements.
Right, right. So she's got something.
Okay, this is what the Constitution says, according to my revisor, who I asked to get it for me. No right-of-way shall be appropriated to the use of any corporation until, well, this is this eminent domain law. Okay, until full compensation therefore be first made in money or secured by a deposit of money to the owner, irrespective of any benefit from any improvement proposed by such corporation. And to your point about the right-of-way and the minus, I think I remember seeing some of that too. But I'm asking, the question now is that for tax purposes? Are we taxing minus that? But the Constitution says the right-of-way is owned by the landowner. So the minus part, is that taxation purposes? Does anybody know?
I think that was in that court case that the court overruled on this particular case. But they overrule a lot of times on other cases too. But again, as a county, I'm not a county commissioner, but visiting with county commissioners, visiting with township people, the difference is where that right-of-way is. And when we did anything, we did not pay any landowner because that right-of-way was there. It's kind of hard to explain. It's kind of an invisible line. And when the property is taken away from the county or the county closes that road, it reverts back to the original landowner to the center of the road and no more. But that does not give you the right to lease that out to anybody, to hay the ditch unless you get county permission or township commission or priority to anything on it. And it's on the deed in the abstract, even on your house. Your house is good to the center of the street, but you can't go put anything in the center of the street. And if the county comes or the city comes or they come to raise sewer or drain, if it's in the easement, they pay you property damage for destroying up on your street, but not on your property, but not on the street. And that is a question. I agree with you, and it is very hard to say. And I understand everybody that was involved in that deal. But that's where we have to decide. The landowner does not get any compensation. Now, if you cross on the backside of that survey street stake, you get compensated. And that's when the rule of eminent domain comes in. Even being on the power company board, we had to be careful. You couldn't put a pole on private land. You could put it in the easement, but you could not put it on the other side. And then we even ran into issues where people would attach their fences to the pole. That was 1 foot in from the property easement, and technically that was illegal too. So it's a difficult situation what you're saying, but that's why that rule is in place, because then the landowner, you couldn't take the ditch by eminent domain. It was already taken on the abstract and deed and filed for at the county register's office, register of deeds office. And that's the question I got. When it says that on the property, if we have any real estate people here, when you sell a piece of property, that's designated on that deed. You own everything but the right-of-way or any easement as of record.
And we will do that in just a moment. We're stacking up, so let's keep moving. Representative Fairchild.
Thank you, Mr. Chairman. I probably can't say it any better than Representative Seward said. I agree with everything that he said, and, you know, I just don't view this as being a private property rights issue because, you know, I agree with him that the county owns the right-of-way, and, you know, as far as the eminent domain part of this amendment, I just don't think that's necessary at all, since my view is that the county owns the right-of-way, and also, I also don't even believe that it's constitutional to use eminent domain for private use. I know that there was a Supreme Court decision where they did rule that it is constitutional for private use, but that was a pretty controversial 5-4 decision, and I didn't agree with that decision. You know, I agreed with the 4 in the minority, and so, you know, I don't agree with that eminent domain provision. I disagree with this. I'm just in favor of this bill because I don't view it as being a private property rights issue, because I view the county as owning the property and not being individually owned. But I'm going to be opposing this amendment for that reason. And also just because I think the amendment is basically just rewriting the entire bill, and it's really not, in my opinion, making small changes or trying to improve it. I think it's basically just rewriting the entire bill from my perspective.
All right. Now, it's a real estate guy.
Yeah, I think
Representative
so.
Thompson, thank you.
Thank you, Mr. Chairman. A couple of things, a statement then a question, if I could, Mr. Chairman, but I think there's a little bit of confusion about an easement or a right-of-way. An easement or a right-of-way is a form of ownership, but it falls short of owning the property in fee simple. That's what the landowner normally owns the property in. They have all rights, right? Surface all the way to the core of the earth, including air rights above it. An easement is kind of like a lease. It's a form of ownership, but there's certain limitations that you can do with a lease or an easement or a right-of-way. So that's the statement. The question I have, and Kyle, I think specifically to you, if I could, on the balloon on page 2, line 23, I believe it is, specifically to item D, says pay 125% of market value as just compensation to affected landowners. The landowners have already granted the easement. They have no say unless it gets off the easement onto private property. They've granted the easement to the county, to the township for the purposes of a road. So how are we going to determine, and who's getting paid 125%? Why is 125% the number, and who decides that number? I mean, if in Joe's neighborhood, there was a farm on that side of the section sold for $2,000 an acre a week ago, a farm on the other side of the section sold for $1,000 4 months ago, who says what 125% of fair market value is? I mean, to me, that's a statement that's going to get us way, way out in the weeds on litigation, trying to decide what's fair compensation. And again, why is the county paid for that? They have a form of ownership that falls short of fee simple, so they can't convey, they can't deed it. Just a question.
I think that brings up a lot of very fair points. There certainly might be a lot of practical issues with the implementation of some of this language. Additionally, the language on page 3, the new subsection K, if it were the county or township using eminent domain, then would they have the interest, I guess? How that wouldn't necessarily be transferred to the owner who's installing the pipe, that sort of thing. So I agree, it creates a lot of questions. As an attorney, I can always fight kind of on both sides, and I have arguments kind of prepared about, like, is eminent domain even relevant to this conversation? Is it not? I'm only one voice. I'm not an expert. My view, to put it very shortly, is eminent domain doesn't seem very applicable to this particular situation. So I don't have a direct answer to your question, but I do have some concerns. I don't know if the chairman, he probably doesn't want me to go into too much detail or anything, but that's where I stand currently.
Okay. Representative Carlson.
Thank you, Mr. Chair. This is way, way more simple than everybody is talking, but I'm not in real estate, nor am I a farmer. But when somebody that owns land, and whether they have cattle or whether they plant, there's their fence. If their fence goes too far over, well, the county comes and tells them, you got to move that fence. You can't plant and then, receive the profits off anything further. That's it. When the county mows the right-of-way, they mow that. It's not the property owner's responsibility to take care of that easement. It's supposed to be the county. Now, as candidates, when you go out and you place signs, you should ask that person, may I put a sign in your yard? And it's out of the country. They say, heavens, yes. And then they take and they put it out there. And what happens? Well, we all know. The county comes along, they pick up that sign. Because it doesn't matter if you have the owner's permission. The county says, that's my property, and you cannot put that. And boy, we've got some stinky county people that are really picky about that. They think that's fun. So I'm just saying that the county, I think, believes they see it, that they own that property, that easement. And that's kind of just my simple way of putting that. It appears to me that that easement is not owned by the property owner. Thank you, Mr. Chair.
Okay. Other questions or comments? Representative Probst.
Saw Representative Minix raise his hand too. I just, again, I really don't want to belabor this. I do want to get it right. I feel like there's two things we haven't adequately addressed, and we need to. Are we considering agriculture a public good? Because in my view, when we're talking about the use of the right-of-way, and I asked research at one of our previous meetings for an answer to this question, and based on the court order, they go back to two previous court cases that say the right-of-way can be used for the public good. And we define that as utilities, telephone, water, things like that. But in this case, the court is saying that there's not a public use in the pipeline that is at question. Unless we're going to redefine in statute agriculture as a public good, which is something we could do, but if we want to make that move and define agriculture as a public good, we eliminate the right-of-way issue, in my view. If we're not willing to do that, then we're going to have to establish a process to allow agriculture to use the right-of-way, because the other issue we have to decide is who actually owns the land. The county having a right-of-way, in my view, gives them the right to use the land for public good. It does not mean the county owns the land. And if we defined agriculture as a public good, the county would have the right to say that pipe can go there, no questions asked. If we agree that, but we have to agree whether the individual owns the land or whether the county owns the land to allow a private enterprise. And if we were talking about something besides agriculture, and I said I wanted to set up a market in a right-of-way and sell a bunch of trinkets, the way we're headed, I'd be able to do that, because that's the use of the right-of-way. And I'm not a public good. I haven't been defined as a public good. And I'm not trying to belabor this. I feel like I am, but I really do think this is a big issue, and it's a big issue I think we need to solve, or we're going to end up with a lot of problems down the road. So from my view, we need to be looking at those two things. Are we considering agriculture a public good? And if it's not currently defined as a public good, we have a conflict in the right-of-way use. And we also have to determine for this committee who owns the right-of-way. And if the county has the right to use it for a public good and agriculture isn't considered a public good, then that's where the crux of the problem is.
Okay. Representative Newland, then Representative Seibert. So Representative Newland.
Thank you, Mr. Chair. I really think it boils down to more than just who owns the property, who controls and owns the right-of-way. Because whoever owns that right-of-way and controls that right-of-way has per se, or has the say, in how that right-of-way is used. And I think that's where the county owns and has the right-of-way.
Which is why I was happy with what we passed out last time. Because I thought we established pretty well a process for the county to make that determination and blended the rights of the private property owner and the rights of the county to take care of its business.
Representative Seibert.
Yes, thank you, Mr. Chair. I agree with the last two speakers. The difference is, I think it's defined on your abstract because it says you own the property, which is 160 acres or 80 acres or 20 acres to the center, less all right-of-ways and easements. So right there, it's in the statute that you don't own it. You have possession of it. It reverts back to you if the county gives it up or local control decides what they're going to use it. And you can put up something on the county if they give you permission to do it, but you can't build on it. You know, but I think we're, like you said, we're making it too difficult because I think it's already in their abstract that you defines where you own it, and that's to the right-of-way. And again, somebody else, previous speaker said, you build a fence on that side, if it's 6 inches over, a township or a county can come and take it without even asking you. So I think that defines who owns it.
Representative Thompson, then Kyle will kind of give us.
Just real quick, and I'm not trying to split hairs here, but there's two ways to own, as a county or a township in the state of Kansas, they own road right-of-ways two different ways, either through an easement or a right-of-way. If they have an easement and the road is closed, you are correct. It goes, or I'm sorry, if they have a right-of-way, it goes back to the owner of record, whoever the adjoining property is. If they have an easement, it doesn't automatically revert back. We deal with this a lot of times with railroads. Railroads are the same way. They either had a right-of-way or they had an easement. It's handled two different ways under the eyes of the law. Okay? You're right that it's on the abstract. It doesn't clearly define on the abstract. It just says you're buying the property subject to an easement or subject to a right-of-way of public record. Has to be recorded in the County Register of Deeds office, or it's not a right-of-way of public record or an easement of public record. So just a point of clarification. Thank you.
Kyle, can you kind of make some sense of all this discussion then? Answer some of our questions?
We shall see. First, I'm going to just tack on one additional point to the previous speaker, that it is possible for a road to be dedicated to a county, and in that case, then they actually do have full ownership. Right, they own the property lying underneath. So a lot of the conversation we've been having and the language that's in this balloon, some of it assumes that the eminent domain process is needed because inserting these pipelines like this would be a form of taking. And in our previous meeting, one of the conferees mentioned that wouldn't maybe be applicable because a taking has already occurred in the past. That's part of how the road was founded, if it wasn't dedicated. And so I kind of want to expand on that just a little bit. We've had statutes since 1868 dealing with telegraphs, cutting edge technology, and it said way back then, corporations created for the purpose of constructing and maintaining magnetic telegraph lines are authorized to set their poles, piers, abutments, wires, and other fixtures along, upon, and across any of the public roads, streets, and waters of the state. And then there's some qualification language. And later, as time passed on, that provision was expanded to telecommunications. So you could think of things like AT&T or Verizon. They're private businesses, they have fiber optic cables and other things that are in the right-of-way. And from what I understand, I tried to get a hold of the Department of Transportation to get a little bit of clarification. So I got an initial answer, but I wasn't able to get a hold of their attorneys yet. But in this type of situation where you have a county road that's already been established back, a long time ago, likely when it was established, the county they paid just compensation to the landowners to make use of it. And they allow sometimes for these types of private entities to basically piggyback on top of their existing easement. And there's not an additional taking necessarily, and the landowner isn't going to be receiving the just compensation from this private entity. There are always qualifications for these types of things, but I'm speaking in generalities. So my possible response to some of the previous conversation is that this situation with a private entity inserting the pipes and the right-of-way is separate from different entities condemning the land themselves and utilizing the eminent domain process, because we do have robust laws if that's what's being utilized. And in law, I mean, we give some utilities and some different entities the power to use eminent domain. But in this case, we're talking about an entity that's just piggybacking off of an existing easement that's in place. So again, I could argue it either way, but that's my response to kind of try and temper the current conversation.
Representative Minix.
I think we had some noble aspirations here to allow for agriculture to progress in the future, to allow a process that people could amicably get together and cooperatively move forward on some things. And those things that have happened in the past that were amicable, I wanted to grandfather them in. We've all got different opinions on whether who owns that easement of the right-of-way. Sounds like a couple judges here recently have said maybe the counties don't have explicit authority under state statute. The counties do have explicit authority for utilities. We can all agree to that. This is slightly different being private. And I appreciate the comments about trying to change the classification or something, but I was just trying to come up with a smooth process that if people all agree can move forward without having some roadblocks. And I do have another amendment if we can kind of discuss through this one, and if this passes, fine. If not, then I have another alternative that I'd like to bring up if we could.
Okay, we have talked about an hour on this, so Representative Carlin.
Thank you. I appreciate the previous comments. Just want to remind you in F on the amendment, it says, oh, no, that's not the one. But I know I read it that said, if the owner and the private person cannot come to an agreement. I mean, eminent domain is only used if you can't come to an agreement. And so that is in the eminent domain law that I'm citing here, that it would be, and there is a spelled out process in that law. It's not spelled out in this amendment, but it's spelled out in the eminent domain law, who has to do what to get through the process. So it's not a matter for a court to decide or something else if you follow the process that's outlined. And the eminent domain law, it's public use versus private use. And that's what we have to realize, that in this case, we had two gentlemen in the room who said, he didn't even tell me he was putting the pipe in. Okay, one said, and the other said, I need this for my business. That was the two arguments that we had. So one was for my business and one was for my property. Those are the things we're looking at. A couple of things I wanted to say about campaign signs. The reason the county or the city can pull up a campaign sign is because they write an ordinance and they pass it through the public law process that allows them to say where you can put a sign. And that's because it's not safe if you put a sign where it's visibly an obstruction. So that's why those laws are in place. And they're local laws. Some do and some don't have those. But the courts have decided in numerous cases, and especially recently, that these pipelines are not a public use, they are private use for personal gain. So that's my comments, and I don't know.
All right, Representative Orr.
I'll weigh in on this. The very first section makes it very clear to me that this only involves people engaged in an agricultural purpose. And we are trying to mix, I think, sometimes a utility here with the private agricultural use. So I think that's the premise of the bill. I think we sometimes forget why we're dealing with this, and we're dealing with this because we have a court case in Phillips County that was decided in favor of a landowner whose property, a pipeline, had been placed with the permission of the Board of County Commissioners, but without permission from the landowner, in the road right-of-way bordering the landowner's property. And some of the discussion I've heard in here, and I agree, that if the county has this right-of-way, I don't understand why the property owner bordering that even has to sign off on it, but that's what the court ruled. So it seems to me we have a conflict of understanding what we hear, and if Kyle, if you could weigh in and explain this to me. So my question would be, if I'm driving my old pickup down the road and have a flat tire, and I pull over in the ditch in the right-of-way, am I trespassing? Thank you, Mr. Chair.
Off the cuff, I would imagine in that situation, you're still ultimately using the road for its intended purpose, the right of way. You're not just camping out there for the sake of it. So it likely would not be a trespass. But to take a quick step back and to address your question, I think a key part of the court's decision and something to remember is that if you are in a situation where the landowner who owns that underlying property has not given permission for this type of use, it's the ownership, according to the court case, the owner who gets kind of the final say. But the exception is if the legislature, who is the ultimate authority over the right-of-way, steps in and expressly gives statutory authority for a person and entity to do something else with that right-of-way. And that's that statute that I'd mentioned about the telegraphs and telecommunications. Those are statutes that were put in place by the legislature to allow this extended use. So if this bill weren't to pass, I think it would, there's a pretty good argument to be made that the court's opinion could stand, that if a landowner says, no, this is my property and I don't want it used that way, that would be the end of the discussion. But if the legislature allows through legislation particular uses, then that is what would ultimately trump.
Okay. All right. Well, and again, we're giving this almost a full hearing again, but we want to make sure we get this correct. So thank you all for staying with us. So Representative Smith.
Thank you, Mr. Chair. I would like to, with your permission, ask one of the conferees from before to come up, Aaron Propelka with KLA, to come up and answer a question about the ruling. I believe that you gave some on the ruling that brought this about. My understanding is there was some reference to legislative intent.
Thank you. With your permission, I think what I'll do is maybe just read from the case itself, because I think the court maybe puts it a little better than I can. And I think Kyle started to explain it. And it's that first off, the county has already paid for the right-of-way. That's clear, and when you open the road, they pay for it. So that, they've already paid just compensation. And so actually, in the case, the plaintiffs tried to make the claim that only utilities that have eminent domain authority can do that. And the court said, no, 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 no. The county already controls it. And so the legislature can step in and say, we believe this is an intended use of the road as a public utility. And so I'm just going to, with your permission, read a paragraph. It says, so this is out of the opinion on page 9. If you have that, you can follow along. So far, the court has discussed flaws in Nelson's argument. So that's the defendant. But Ross, plaintiff, also makes an argument that is not accurate. He argues that utilities get special access to the road right-of-way because they have eminent domain powers and are transporting commodities for the general public. Although the court agrees that some utilities get special access to the right-of-way because they're using it for public benefit, the court does not agree it is because they have eminent domain powers. As Nelson, and that's the defendant, correctly points out, if utilities get special access to the right-of-way because they have eminent domain powers, then the utility would have to pay just compensation to the landowner. Instead, some utilities get special access to the public right-of-way not because the legislature has granted them power of eminent domain, but because the legislature, which represents the public and has unlimited control of the streets and alleys, may grant a privilege or franchise in them without providing for payment of compensation. So that's and that's from the judge in this Phillips County case. And he said, and I'm just going to paraphrase it again, Compensation's already been paid. If the legislature decides this is a use of the right-of-way that's already been paid for, these pipelines can go forward. So, and I'll just say, just while I'm up here, we're in opposition to this amendment, and if you want, I can go through point by point, but this amendment would essentially gut the whole point of this bill. So, thank you.
Okay. Thank you. Anything else? Okay. Okay. All right. If seeing nothing else, if you want to wrap up and then how are you going to proceed?
Mr. Chair, I wonder if I could get Zach Pastora to speak to these issues that we've belabored just a little bit. Thank you, Mr. Chair.
Thank you, Chairman. Thank you, committee, for the opportunity to speak. Just a few of the concerns that we brought forward in the original testimony. We're just trying to reconcile some of that as far as providing for the private entity to utilize a public right-of-way and impacting the private landowners. I think the bill did pretty good to spell out the opportunities for the pipeline owner, but we thought that there was some missing protections for the affected property owners. And so those were some of the concerns of, we thought, well, if we're going to allow a new use for this right-of-way and these agricultural pipelines, and think about what kind of pipelines these are going across private properties, and maybe it would be for the benefit of the county. If the county decide that, that'd be fine. We felt very strongly there ought to be some sort of just compensation, because we're entering a little bit new territory on some of this by providing some private pipeline ownership on the public right-of-way. And you heard some of the other opponent conferee that they have other models for how to do this in Oklahoma with oil and gas, and that might be a consideration. But in a lot of these, we just thought, hey, there ought to be some sort of explicit intent here that there ought to be some sort of some just compensation for the intrusion upon those private properties by these pipelines. And if I may, the one thing about the grandfathering of the issue is that any new pipeline or existing pipeline that would be created, would be provided for in this, we would just ask that they go through the application process so that, you know, they're locatable and all the other protections through the county. And I think they'd have a pretty easy time to do that, but it would provide for a public hearing and some of the notification requirements. So those are just a few of the thoughts of why we included the striking of the grandfather clause. So, thank you.
All right, Representative Minix, thank you.
Mr. Chairman, I would like to offer a substitute bill or substitute amendment to this amendment.
Okay. What's that? You going to vote on this one first?
Mr. Chair, I'd
Okay.
like to hear from him before we vote on this. I'd like to hear a bit, you know, somebody else's hard work on this.
Okay,
I'd like
but,
to discuss it
well, it's,
as part of the discussion.
but what we do is we're on your amendment right now. And so he's offering a substitute, if he offers a substitute motion for a new amendment, that would be the amendment then. See, we wouldn't vote on yours.
That's okay.
So,
Maybe I would offer one later. Unless we vote it down.
that would be, well,
I'm willing to take that.
okay.
Mr. Chair, I'm trying to solve the problem, as we all are. I'm not married to this or anything else. I did the best I could to try. I'm a private property rights person. I always have been. I'm part libertarian, and it's just in me. So I really want to work this out, and I'd like to hear his ideas. We can discuss his ideas, and then maybe one of us might withdraw.
Okay, well, Representative Minix, do you have your amendment?
Yes, we do. Mr. Chair, do you require a motion?
Yes.
Mr. Chair, I move to propose this amendment to basically House Bill 2531 or the prior amendment as is on the floor.
As a substitute?
As a substitute.
Second? seconded by Fairchild. Once they're distributed, we'll call on Representative Minix to explain. Just one page, correct? Okay.
Actually, 2 pages.
Okay, is it okay to have them just both out? Do you want them considered at the same time?
Yes.
Okay.
As one substitute.
Part 2 is, do you have it? All right, there's another part, I guess?
Yeah.
Okay. Thank you. Would you like to explain, or do you want to have Kyle explain when everybody gets theirs?
I think Kyle can do it quicker than I am.
Okay.
With the time we have, and then I would like to make a comment.
Okay. So everybody has their copy, so Kyle, if you would, and there are 2 parts to this amendment, so if you would like to explain.
Thank you, Mr. Chairman. So for the first balloon that was handed out, where the changes on the first page of the bill, it would be inserted on line 24, and it would say regarding the approval and application process, the person who makes such a request and submits such application under this subsection shall be the same person who is the owner of such pipeline upon approval of such pipeline in accordance with this act. And from what I understand, the intent there is just whatever person, whatever entity is actually going through the application process with the county would have to be the same person who's the owner of the pipeline going forward. They couldn't just be 2 separate entities or people. And then for the second balloon that was handed out, it makes a change to page 3 of the bill, starting on line 1. It would add this additional language: if a Board of County Commissioners vacates a road pursuant to KSA 68102, an owner of a pipeline approved under this section shall remove the pipeline within a reasonable amount of time as determined by the Board of County Commissioners, unless written permission is obtained from all persons acquiring the property interest of the county after the road has been so vacated. If removal is required under this subsection, the owner of such pipeline shall return the property to its functional equivalents before the removal, and if such owner fails to make the repairs, the persons acquiring the property interest of the county shall have a cause of action against the pipeline owner for such violation of this subsection and may recover damages, including reasonable attorney fees, if the pipeline owner is found liable by a court of competent jurisdiction. And then a new subsection would be added to say, if the owner of a pipeline permitted under this act transfers any portion of such pipeline, such owner shall notify the county clerk of such transfer. So this second balloon is trying to address different types of situations where ownership is being transferred. Thank you, Mr. Chairman.
Representative Minix.
Thank you, Kyle. Very, very well put. I took our existing bill and ran it by 4 different lawyers to try to clean up some of the language that we had, to take some of the ambiguous nature out of it and make it as clear as possible. The process is exactly the same as we had passed out a couple weeks ago of full notification. It allows people that want to put a pipeline in, if everybody agrees, then the county commissioners can authorize it. It's basically kind of authorization from the state to the county commissioners to act as a local agent for these agricultural pipelines and for a process to go forward with full agreement. If there is an agreement, then they're not allowed that right away. The individual business would have to find a different route or compensate someone to get their approval for the right-of-way pipeline in that nature. So that's what I was trying to do. It does still have the grandfather clause in, the same as the last, or our prior bill did.
Representative Smith.
Thank you, Mr. Chair. Representative, I've got a question. I'll let you finish your conversation. I've got a question, and by way of explanation, I want to pose a scenario. It seems to me that one of the questions brought up in caucus on this, let's say the owner of the pipeline passes away. Eventually, 15, 20 years down the road, his estate is sold, and no one's aware that he had this pipeline. There's a problem. The landowners adjacent now want the pipeline removed, and the county discovers, oh yes, it was his estate, no longer there. The persons responsible under this are no longer present. Who then becomes liable for that?
I believe it'd be like state law concerning any other property that passes on, or if someone buys or assumes that property, they take on all the easements and obligations that were there before.
How is that recorded when I get that pipeline in there? How is that recorded that it would be recoverable? The information would be recoverable to the landowner or present landowner.
In my county, as an example, once someone made application for this pipeline and it was approved, there are records at the Register of Deeds office that say on this particular quarter of land along this roadway, there is a water line. There's also many times we require the phone companies to put their lines. And so if you do what is it, 811 dig safe, they can many times go to Register of Deeds office, get that information and go out. They at least have an idea what they're hunting for.
I agree with that. If you're buying that land, that's the adjacent landowner. But if you're the person who is putting the pipe in, that's not attached to your deed for your property that you sold. That's on another person's property. So how do I know buying this piece of property from which it extends that it's laid along other people's property? How do I become the ownership of that pipeline if it's not in my deed? How do I know it's there?
If you bought a piece of land that had someone else's pipeline underneath it,
it would be on the deed.
It should be shown in the Register of Deeds office.
Right.
And you bought it knowing that's on there.
Right. But if it, so that would be the adjacent landowner. I'm talking about the originating landowner. So the pipe leaves my land. The deed doesn't necessarily tell me that it's on Joe's land over here. That deed doesn't tell me that. How do I know that once I pass and nobody else has record of it? How do they know when they buy that land? How do they know they're taking responsibility for that pipeline?
I don't believe there's any connection there that they wouldn't know.
Representative Thompson.
Thank you, Mr. Chair. It depends if it's on the right-of-way or on private property. If it's on private property, they have to have an easement to install it. If they've had an easement of public record, it's going to be recorded. It's going to show up on your title search. And some of those gray areas, I'd hate to tell you, there's a famous Latin term called caveat emptor, which means let the buyer beware. As a buyer, you have to do due diligence to discover those things. And again, if it's on private property, they would have had an easement to have permission to put it on that private property, not in the right-of-way, on private property.
Representative Smith.
Right. Thank you, Mr. Chairman. And that would be my only concern. I think you're right. I think then it's going to fall back to the present landowner, regardless if they were aware or not unaware. And that's just something I think we need to be aware of. It's not a game killer for me. It's just something that I think we ought to be cognizant of.
Representative Seibert.
And that brings up a good question. But again, when a phone company or a broadband company or somebody abandons their line, they don't pull it up and there's no record of that other than 911. Even 911, they'll take it off the record so you don't know it there. So if you do contract work or do ditch work, you might pull up a line that was abandoned and you don't know it. So it's the same question you're asked. It's already there. Once it's abandoned, it's abandoned. So, and there's no requirement by any of those utilities to remove those abandoned properties.
Representative Carlin.
Just as a comment on Representative's comment there, if I have a cable in the ground and I abandon it and it's no longer in use, it's not going to do any damage to anybody. But I think if you have a line full of pig effluent and it breaks or is abandoned, it might be a different matter. And I think because of that, that's why I offered the things I did. And I would like to say at this point, we would improve this amendment if we would add the bonding authority, the bonding requirement in line F of my amendment, which the bond would go with the pipeline. It would be a bond to the pipeline. So it would be there in the future, whoever owned the land. So if the pipeline had to be pulled and cleaned up or repaired, there would be a bond that would pay for it. And I guess the county might, I don't know who manages bonds, I'm sorry. This will be a point of contention on the floor. I can promise you that. I've heard it all over the building. So thank you, Mr. Chair.
Representative Minix.
Mr. Chairman, I would consider that a favorable amendment if the sentence above that says the county commissioners may require and leave it up to their judgment. I think Representative Carlin's suggestion is a good one. And leave it to the county commissioners to say, you know, if it's effluent or if it's fresh water, those might be two entirely different things, and leave it up to their discretion to ask or not.
Representative Carlin.
Thank you, Mr. Chair. And I agree. I think that's a very good point, because the county knows whether there's dissension or not in the community. Those people know what they're dealing with, and they can make the appropriate decision. I think that would be acceptable. And I appreciate that. Thank you, Mr. Chair.
Okay. Yeah, Representative Probst.
I can see the fatigue on your face, and it's. I just wonder on this, since we're having this discussion and looking at how to do this, I want to raise the question of whether we want to, on Representative Minnick's amendment, pull in the language regarding the Board of Trustees to address that issue, and possibly on page 2 where we talk about if requested by a county commission or township board to accomplish construction in the right-of-way, that the owner shall relocate, adjust, or remove the pipeline. The remove wasn't in there before, but I just want to open that up for discussion. Are there parts of this specifically addressing townships and maybe the need to remove a pipe under certain circumstances that we want to incorporate into Representative Minnick's amendment?
All right. Okay. So where we are, we have not accepted that amendment yet, so we're in discussion on the Minnick's amendment. Now, I'm going to ask one of these former county commissioners the role of township trustees. The way I understand it is, and I was one of them, and maybe I didn't understand either, but my authority was basically making sure the roads were taken care of, cemeteries and so on that we had in our township. I cannot recall a county commissioner calling me and asking my opinion of anything. So I guess that's, and not to be, I mean, I understand the point, but I don't see anywhere else that I can ever recall doing anything my time farming where I called up my other trustees that, can I get your approval to do running a water line from the well, which you end up doing on our own property for livestock watering. So I guess if any of you former commissioners want to raise your hand and comment on the role of a township trustee, are we creating now a new level of approvalship for a right-of-way usage? So, Representative Newland?
If you want to really muddy the water, ask the township to get involved with the county commissioners. Leave it to one entity to make these decisions, and you'll have a lot clearer outcome with it.
All right. So, again, just want to, as I'm going through this process, of Representative Thompson.
The problem is, Mr. Chairman, thank you. I know some counties, and there's not a lot of them, but some counties still operate their roads and all the road decisions through their township trustees. Reno County, where my friend Representative Syward's from, does that. Cherokee County in southeast Kansas does that. They have parallel authority to most county commissions, and I think it's rare. I don't think there's maybe a handful of counties in the state that still do that. But in those counties that do make those road decisions at the trustee level, I think you have to grant them the same authority. I mean, I'm sorry, that's just the way they have always operated.
Ms. Seibert?
Thank you. And I agree with the previous speaker because there's consolidated counties and there's county maintenance and there's townships yet. So but it should be still up to the local government control.
But may I ask, Senator, I'm giving you a promotion today. Representative Seibert.
I'll quit.
Well, that's true. So in your time as a township trustee, would in your meetings, would something like this get brought up, or you to first sign off before we'd go to the commission? Have you dealt with that before?
I'm going to say in our county that 95% of everything the townships decided was okay, and the county did not get involved in it because we were the authority over the township. They were over the county roads. Now, if we had an issue, we could go to the county attorney, and we could go to the county commission and ask for backing or approvals of what we were doing, and just like the previous speaker said.
Okay. Representative Carlin. Okay.
It intentionally uses the word "or" because we wanted to give someone in authority this responsibility, not both.
Okay, Representative Murphy.
Yes, thank you. Yeah, the or is good. I was 12 years as a trustee, and we actually, in Reno County, we had a number of times when the county commission called me, said, we got somebody wanting to do X, Y, Z, but we were in charge of all the township roads. And so it was done through us. So, yeah, I think or is a good solution.
Okay, Representative Minix.
I think it's a good idea. There are a very small handful of counties that still have township road maintenance. And so every place within this bill where it says county commission and we added or township board, I think would be appropriate. And that would cover all 105 counties, I believe.
Okay, Representative Orr.
Yes, I think this is a good idea. In our county, we actually have some townships that still operate. But what they depended upon the county to keep the records, and this goes back to what Representative Smith said a while ago, and in any situation in our county that this would be requested of the townships, they would simply say, go to the county, get their approval, make sure it's on record, and if they approve it, we'll approve it.
All right. Since we're going long, let's go ahead and make sure we all have a full understanding. So if Representative Minix accepts this as a friendly part to his amendment, even so, if those counties have consolidated power in a sense, and the county approves it, can that landowner go, hey, Township Committee, you need to vote to oppose this? And then so what happens to those? If we're going to have a discussion, let's have a discussion, because there's no reason to have a fight about an abandoned pig line. Because to me, honestly, I've been quiet pretty much for the hour. This is much bigger than affluent. I mean, that's for another day, for another discussion. So that I'm just trying to figure this all out. And so, Representative Seibert, clarify it.
I wish I could. All I'm going to say is anytime we had an issue, it went back to the local authority that was an elected position. If it's in a township that's a consolidated county township, that went to the county. There was no township trustees involved in it, I believe, but that's a different county rule in a different county, not in ours. If it was something else, then it went to the county. But it went back, every time I talked to the county attorney, it was who was the elected official for that jurisdiction.
All right. Yes, Representative Probst.
I wonder if we'd be okay, if we're okay with this in concept, would we be okay with saying, or township trustees, and allow Kyle the flexibility to massage that language so that it applies only when the township has control of the road? That every other case, it goes to the county commission. Only in those cases where the township has the authority over that road, does that apply to the township?
Let's hang on. First, are you
Mr. Chairman, that would be a favorable amendment, I think, if that type of language, and we're only talking a very few counties, and it would eliminate the problem in the other 100 counties, and it would put the commissioners in the control seat there. I think that would be favorable.
We'll stack these up. We'll get to everybody. I want to go to Representative Fairchild first, then you, Kyle.
Thank you, Mr. Chairman. I just have a question about the procedure of all this. I don't believe that you can amend an amendment, correct? I mean, I think that he would need to pass his amendment first, and then they'd have to come up with an amendment to the bill after his amendment passed. Wouldn't that be correct?
I guess that is true. I'm used to amending amendments.
I served with Representative Tom Sloan, so I'm very familiar with the concept of conceptual amendments.
I was his vice chair, so that's where I get it from. Okay. Attorney, how do we do this? What's the best way to do this?
Good news, bad news. Ultimately, it's up to the chairman how you want to proceed. Right. But the idea of conceptual amendments, it gives you a lot of flexibility. You could act as though the conceptual amendments that we have been, adding on to the physical balloon are a part of the original amendment that he offered. We could act that way, or as you were saying, withdraw and then do another motion, including the conceptual amendments. But I think you could act as though they are a part of the original amendment. But I do want to take a step back just to kind of clarify some of this conceptual language that we would maybe be adding. Because I'm not completely familiar with all this sort of process with the townships and the counties. So I want to throw this out there and then tell me why it would or wouldn't work. So if in subsection A, when it's talking about the general approval language, could something be said like, upon approval, under and across the right-of-way of any county road as defined in that statute and amendments thereto, by the applicable Board of County Commissioners, and then after that, or any township road as defined, yada, yada, and amendments thereto by the applicable Board of Township Trustees. Would that get us close where if approval is being given for pipeline that's being added to a county road, that approval must be given by the applicable Board of County Commissioners. And then the same with the township. If the pipeline is being installed in a township road, it has to be approved by the applicable Board of Trustees.
Okay.
Tell me where to go from there, if that's not it.
Representative Seibert.
This might be a question to, it's my understanding, again, in a unified township, which is the county maintenance, there is no more townships. They gave up that responsibility to the county. So is that correct or not?
I don't know off the top of my head, but my question in response is, in that case, do they still have township roads, or are they all county roads if it's a unified government?
In a unified government, when the township gives up their right to maintain them, the county commissioners, my partner here, is a county that is unified with some townships and some without. So the question is, I believe, correct me if I'm wrong, and if my partner here agrees, as a township trustee, when we give up that right to the county, then there is no more township boards. The county is over the control of them.
You still have township.
Okay.
Mr. Hall back there? Okay. I saw your boss leave because he probably knew that I might call on you. Okay. Do you know, because do township trustees have any right-of-way authority anywhere, even in those that have not been kind of unified? That's a Bushism. Unified, long day. So, I mean, I guess, again, is that a moot point? Or are we going to cause more confusion because we're basically giving them authority they haven't had before?
Association of Counties. There I go. Deputy Director for the Kansas Association of Counties. Mr. Chair, I've been digging through the statutes. That's actually what I was doing back there. That's why I had my head down. I wasn't trying to hide, although maybe I should have. But I'm looking at 68-115, and it talks about the differences when you're opening or repairing roads by the county engineer or the township trustee. And I think that's probably the statute that applies in this situation. But I haven't looked at this statute in a while, and I just opened it up just right before you called my name. So I'm doing this a little on the fly. And I'm looking at section B, and it says if the owner of any property adjacent to or abutting a township road which has been laid out but not opened prior to the effective date of this act desires to have such road opened, it shall be the duty of the owner, blah, 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 to, they have to contact the township board to maintain the road as requested. So I think there is some role for the township trustees in that situation. I will say that the township road, the township, the way they do that, most of our counties are now county unit systems. I think there are less than 20 counties that have the township system. I can't remember the exact number. I didn't bring that with me, but it's less than 20, I believe, at this point. So I hope that helps clarify.
Very good. Representative Carlin.
And I'm not sure, Representative Sywert might know the answer to this, but a township road might be a road that's less traveled. It could be out in a pasture, like where you might have a facility for animals and need a pipeline. Where your county roads are, people are going places on those county roads. They're even inside cities. Is that correct? So we may have like a pasture road that is really a township road that you would have control over and nobody else would?
Representative Sywert.
Good question, because we had some roads that went through some pastures that we reverted back to the landowners. But it's very defined on if it's a township road or a county maintenance road, unless it's a unified township or a county. If it's a unified county, the county takes care of all the roads, including the township roads, and they can open or close roads if they want to. And my county commissioner friend agree? Okay. If it is a township, then it's still the responsibility of the township trustee. And just like the speaker at the well said there's less than 20, 25 counties.
All right, Representative Minix, I think we're back to you now. How do you want to proceed? Do you want to restate your substitute, or do we want to pull that and call on you to do a new substitute amendment? Is that right? Right. So, but if he,
I think according to Mason's, Mr. Chairman, I need to withdraw my amendment,
yes.
my substitute amendment.
Okay, and the second was, okay, all right. So the substitute amendment has been withdrawn.
Mr. Chairman.
And then Representative Minix.
I would like to make a substitute amendment, and I would propose the amendment that I brought forward earlier with the added language that Representative Probst suggested, which adds township road trustees where applicable in those counties that still have a township road system. And seems like, what was our other change?
Will ones.
And add some language that the county commissioners may require bonding.
Do I hear a second? Seconded by Mosier. I can keep you here all night. I don't know. I know. What's that? I think we locked the door. Okay. And so, and the way you understand with technical leeway from the revisor, right, as with what you have?
Yes.
Okay, Representative Orr?
Thank you,
Discussion,
Mr. Chair.
yes.
I'm confused on what we did with the grandfather clause, which I think is paramount in this bill.
It is
It's in there? Okay, thank you, Mr. Chair.
Yes. Discussion. Representative Carlin.
Thank you, Mr. Chair, and thank you, everyone, for really what I call a healthy discussion of this issue. I think when it comes to the floor, there may be some more discussion of the issue, but hopefully we have satisfied some of the really important issues here. And I thank you, Mr. Chair, and I will support the motion.
If my doctor was watching, he would say, the way you look, Rogers, it's not a healthy discussion. So tell my wife my blood pressure really is fine. So with that, Representative Minix, you may close.
Mr. Chairman, I close and move my substitute amendment.
You have heard the motion to approve the amendment, substitute amendment for 2531. All those in favor signify by saying aye. Aye. Post same sign. We're back on the bill. Newland, did you, yeah. Did you move, who moved the bill? It's been that long ago. Oh, nobody. Oh, that's right. We started with discussion. You're right. It has been a long day. Which he did, well, he moved his. Now we're back on the main bill as amended. Right? Which was Sidney did. That's right. That's right. Do you want to do? No, we need to do that. Representative Carlin.
Mr. Chair, I move that we move House Bill 2531 out favorably as amended.
Second, Murphy. All those in favor signify by saying aye. Post same sign. House Bill 2531 passes out as amended. Thank you very much for your attentiveness. Sorry we were about 15 minutes late, so really we're not that far over. We will do our best, committee. No meeting tomorrow or Friday, but we will have meetings next Monday, Tuesday, and Thursday. So we will be hearing bills and having some informational briefings. So plan on being here Monday at 3:30. Anything else for the good of the cause? Seeing none, we are adjourned.